welcome to Crime in Court. My name is Heather, and this is the Canton Cover Up series, Commonwealth versus Karen Reed, and this is episode 101. We have yet another explosive defense filing, and we're going to be talking about some potential evidence tampering, hiding of evidence, things like that. So let's get started. Please hit the like button. And while you do that, let me remind you that today is January 29th, 2025. So it is 3 years from the day that John O'Keefe was found on the lawn of fellow Boston police officer Brian Albert. And it is also 3 years from today when the MSP decided pretty much they were going to pin it on the girl. So that being Karen Reed, obviously. And we are heading into trial number 2 this year, set for April 1st. But whether that happens or not, we shall find out because they're still litigating all these other things. And this is a pretty explosive thing. And this might even get the charges dropped potentially, but it should if it doesn't. But, anyways. In my opinion. So let's get started in reading through this. Oh, I wanted to also remind you too that Sandra Birchmore, who was the uh she was about 22 years old at the time of her death. She was originally ruled a self-deletion by the Norfolk County ME. However, two separate individual MEs have come out and said, or forensic examiners have said that it was not self-deletion and it was homicide. Since then, the perpetrator of her demise is in prison, federal prison right now, Matthew Farwell. So the reason I bring that up is because it is the anniversary of her death, and I wanted to remind you of that as well. So John O'Keefe's death was 3 years ago today, and February 1st would be 4 years for Sandra Birchmore. So I just wanted to bring that to everyone's attention before we get started. It's believed that her life was taken. I can't say the trigger word, so apologies for all my workarounds, but so her life was believed to have been taken on February 1st. That's when her phone stops. That's when all communication from her ceases. So and that is also the day that Matthew Farwell was seen on her camera going in and out of the building. So she was believed to have met her demise that day. But then February 4th is when she was actually found, and someone from her work finally called for a welfare check on the 4th. So just keep those dates in mind as we go forward in time. All right, so let's get started with this. Again, this is the defendant's opposition to the Commonwealth's motion to exclude certain testimony of defense witness Richard Green. Richard Green, the forensic data expert for the defense. As a reminder, Trooper Nicholas Garino is the uh, Commonwealth's uh, f- their forensic guy. He's a cop, but his expertise is supposedly data. But he didn't get any of the messages between Sandra Birchmore and Matthew Farwell on Sandra Birchmore's phone. So he's either not good at his job or he's intentionally hiding things, allegedly. So let's get into that, shall we? All right, so now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny the Commonwealth's motion to exclude expert testimony of Richard Green. Richard Green, who testified in the first trial. There was no question as to his expertise, and in fact, he has a better CV, a better curriculum vitae or resume than the other experts that the Commonwealth hired. So they have Trooper Garino, and they also hired Ian Whiffen, if you recall, he worked for Cellbrite, and he also made his own Uh, he created his own app, and it sounded like he was basically selling it on the stand the whole time he was testifying. And then there was Jessica Hyde, who I don't even know how to describe her, but she's changed her original she's changed her opinion from the original report that she submitted after Ian Whiffen came along. So again, let's get into that. So Richard Green, as to one, his expert opinion that a Google search for how long to die in sicked, that's the other misspelling, or house long to die in cold, was made by Jennifer McCabe's phone prior to 6:23 a.m. on January 29th, and two, his expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches and deny the Commonwealth's included request for an evidentiary hearing under the standards set forth in Daubert versus Merrill Dow Farms, Inc. and Commonwealth versus Lanigan. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert Lanigan. Instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green, matters that courts resoundingly state are the subjects for cross-examination and the jury, not the narrow function of the Daubert Lanigan judicial gatekeeper. So this is Robert Alessi's filing, I believe. I believe he's the one that signed it first, so usually that's who did it. And he's taken on this case pro bono after watching the calamity of what they would call justice in the Commonwealth in the first trial. So Robert Alessi is now he's added to the team. So no one's left the team. They still have David Yannetti, Alan Jackson, Elizabeth Little, and now Robert Alessi has joined. In the past, we had for appeals. Oh, what was his name now? I can't remember. Hennessy? No, Hennessy was Delphi. I can't remember who they had. Weisberg, maybe? Maybe it was Weisberg. They had somebody for an appeal that was for the SJC, and that's not for the lower court, which, by the way, we still have not heard from the SJC regarding whether it's double jeopardy or not for charging Karen for the first and third charges. So we're still waiting on that. So that's another reason why I'm like, well, maybe we might not go to trial yet because how can you charge her or try to convict her again when you don't have an answer back from them? But anyways, and this whole Daubert Lanigan hearing thing, that's basically just to qualify someone to make sure, like, okay, where do you work? What's your experience? Do you have any education, certifications? What's your experience in doing this? All of that. All of those boring questions in the very beginning, but it helps you learn how that person is an expert. So that is what a Daubert Lanigan hearing is for, not a 2-day Daubert Lanigan hearing for Dr. Marie Russell, which they did, which was basically just to get testimony from her, to get a first bite of the two bites that they want at the apple. So it was basically to see what she would testify to. And if anything, she was stronger in her opinion this time. She made her opinion more solidified, and um, I thought she came off better and more forceful this time around. And this isn't in front of a jury, so she can be even better the third time. All right. So, and she is coming in, by the way. So, Judge Bev, for all the evil that she is, she actually did deny it because you couldn't deny. She has to let Marie Russell come in because she's qualified, overly qualified to testify. All right. So, and again, that's what they want him to do. He's way more qualified than some of the experts on the Commonwealth side. So, moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified, and his methodology pertaining to the subject matter of the instant motion is reliable. As a result, in addition to denial of the motion, no evidentiary hearing is justifiable. So, he's already testified. There was nothing wrong with him testifying before. He's been qualified. He is using a specific methodology, and really that's all you need to what's the word I'm looking for? You need to show that you're using a specific methodology. You can't just come out of the gate and be like, well, A plus C equals F and 32. And, like you can't just make crap up, which seems to be what the Commonwealth is doing to gaslight us all. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny Ms. Reed the ability to present her defense through her well-credentialed, methodologically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. Oh, Bev is not going to like that language. The baseless charges is lodged against her. Pfft, Bev is not going to like that. Anyways, I think they're baseless. I know they're baseless. We all know they're baseless, but it's Bev. All right, so the expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search "How Long to Die in Cold" existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp of at or before 2:27 a.m. and in a deleted state. So this was a search artifact to 27:40 a.m. without any objection from the Commonwealth as to his qualifications or methodology. So recall he did not have to go through a Daubert Lanigan hearing. Marie Russell did. She went through two now. So that was stupid, but anywho. And for good reason, Mr. Green has been accepted in several United States courts as an expert in digital forensics. Several courts. The methodology that Mr. Green employed in the first trial was the same methodology that proffered experts for the Commonwealth employed. Same thing. So, what are we complaining about? That is, Mr. Green and the two proffered experts, so that's Ian Whiffen and um, what's her turban lady? God, I can't remember her name. Jessica Hyde. I just said it earlier. Okay. So that is Mr. Green and the two proffered experts of the Commonwealth received the same raw file from Jennifer McCabe's iPhone 11, verified the hash signature / value of the image file, took the image file and saved it to their computers, servers, hard drives, etc., and then processed and evaluated the image file with the appropriate tools such as Cellbrite Analyzer and magnetic focus or forensics axiom. So these are just two different products doing the same thing. They might parse out a little bit different of information. One might give you a little more, one might give you a little less in this area. So it's just like using two different products for achieving the same thing. All right, so while Commonwealth witness Ian Whiffen used only the Cellbrite Physical Analyzer and ArtX tools, I think that's Ian Whiffen's brand, maybe ArtX. Commonwealth witness Jessica Hyde historically used three more tools than Ian Whiffen. So Ian used what? Two, Physical Analyzer and ArtX, which I believe is his. And then Jessica Hyde used three more tools than Ian Whiffen. And then Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using four of the same tools. Green, I believe, used five tools altogether, including Cellbrite. So Jessica Hyde, it looks like three more tools. I don't know. She used four. What it seems like to me. I don't know. All right, so notably, although Jessica Hyde previously used four of the five tools used by Richard Green in her analysis, all but Cellbrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion. So, in a recent report from her, all of the other all of the other tools that she used, the other products that did the parsing of the data, just happened to be missing from her report, despite her admonitions in her previous reports that it is best to use multiple tools. So she is on the record of saying that. Importantly, it was undisputed by all expert witnesses at the first trial that the 2:27 and 42nd a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using the Cellbrite physical analyzer forensic technology available and on the market at the time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as, and then more comprehensive than, because he used more tools, that for that of the direct for ugh, things aren't coming out of my tongue right now or my mouth. And then more, so he used the same methodology and then a more comprehensive approach that of digital forensic witnesses. That was hard to get out. So he did more than the others. It is his opinion and conclusions that the methodology of the witnesses that differ, but that difference is not a Daubert Lanigan issue. So just because our conclusions are different doesn't mean you get a Daubert Lanigan hearing. That doesn't mean you get to say so. And remember, a lot of it is Hank Brennan not providing actual reasons for evidentiary hearings or whatnot. So he's not even arguing properly, Hank the Tank Brennan. All right, so what was changed since the first trial? The answer is disturbingly Orwellian and brings the prosecution closer to, if not squarely within the danger zone of legal tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensic consultant. So Ian Whiffen has law enforcement in his background. Guys, did you know that? He appears to have gone back to his company, Cellbrite, to have its researchers perform further updates to its physical analyzer program such that the artifact containing the 2:27:40 a.m. search timestamp has now suddenly disappeared from all Cellbrite programs. So that timestamp gone because Mr. Whiffen goes back to Cellbrite and says, no, 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 this can't be. We need to get rid of that timestamp. Can't make this stuff up, folks. Like this is happening in our court, in our current system of law. This is happening. So the 2:27:40 a.m. search artifact has now nefariously become, without explanation, the Orwellian unperson. After Cellbrite completely rid itself of the 2:27:40 a.m. search artifact that is incredibly inconvenient to the theory of the case of the Commonwealth now comes before the court saying the unilateral and unexplained Cellbrite updates to remove the 2:27:40 a.m. search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is most accurate. So it is up to a jury to decide based on what they say. It's not up to the Cellbrite updates that are removing features here. And in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensic axiom, that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and that still contains and shows the 2:27:40 a.m. artifact, nor the several other digital forensic tools that Mr. Green used. Additionally, the motion on the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its burden going forward obligation to meet its going forward obligation to state. Well, I don't know, bad language there. To state how Mr. Green is now suddenly, after the first trial, suddenly not qualified. Yeah, how all of a sudden is he just suddenly not qualified? Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 2:27:40 a.m. search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified. I love that they include that. He's actually more qualified, in fact, in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed includes the same and entire methodology of the proffered witnesses for the Commonwealth, plus his addition of additionally accepted digital forensic tools. To prevent the continued abuses of Ms. Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential uh, maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing, case history of the digital forensics analysis of the 2:27 a.m. search. For 3 years, in this case, there has been no dispute over the methodology employed by the defense to address the issue of the 2:27:40 a.m. search artifact. On June 21st, 2024, Richard Green testified that at the trial that, as a defense expert, without any objection as to his qualifications or methodology, the use of digital forensic tools to analyze data of the raw image file. As he stated in his testimony, after receiving the raw image file of the data contained on Ms. Jen McCabe's phone, Mr. Green used five digital forensic tools to evaluate and analyze the data on the image file: Cellbrite Physical Analyzer, Magnet Axiom, Belkosoft X, Sanderson Forensics SQ-Lite Forensic Explorer, and ArtX. Okay, so through the use of these five tools, Mr. Green found that the 2:27:40 a.m. search affidavit existed and appeared in a deleted state. Those findings were consistent with the April 24th, 2023 report from Trooper Nicholas Garino, who testified as a proffer expert of the Commonwealth in the first trial. Mr. Garino reported that while the 2:27:40 a.m. search artifact did not appear on the version of Cellbrite Physical Analyzer, which was that version there, ending in .29, he had used for his May 4th, 2022 analysis of Jennifer McCabe's iPhone data. Mr. Green had used the then newest version of Physical Analyzer, which did depict the 2:27 search artifact. The newest version was able to pull up artifact in the Brower State DB wall file. House long to die in cold 2:27:40 a.m. on 1/29/2022 deleted. Inexplicably and unexplained up to this day, Trooper Garino did not disclose on his report from April of 2023 that the Axiom program he used at the time did show the 2:27 a.m. search artifact. So, did Trooper Garino purposely hide evidence for the Commonwealth? I'm not saying, I'm just saying. This same exact version Richard Green used, the same exact version of Axiom, and Trooper Garino used that same exact version of Axiom in April. and it should have given them both the same results. So why did Trooper Carino not turn that over to the defense? Or rather, why wasn't that turned over to the Commonwealth, and then the Commonwealth would have turned that over to the defense, right? So they're the gatekeeper, the Commonwealth of the info and who they give it to. So Mr. Green's findings were further consistent across all 5 tools that he employed and remain consistent with findings as of January 2025 with analyses performed in the most recent version of Axiom, which continues to report the 22740 AM search artifact. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensic tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffin only used 2 data forensic tools in his analysis of the data: the Cellbrite Physical Analyzer, his company's tool, ArtX. So his company's tool is ArtX. Notice Richard Green also used ArtX. So Richard Green used both Cellbrite, which is where Ian Whiffin works, and then also Ian Whiffin branched out and made his own company for this ArtX. After performing an analysis using a then on the market Cellbrite Physical Analyzer program, Mr. Whiffin testified at the first trial and reported that he had seen the 22740 AM search artifact. So the 22740 timestamp was correct insofar that it is the time that is shown within the database. It was indeed a deleted record. And that was in a Commonwealth motion depicting the search artifact. Okay, from Whiffen. All right, so thus, while he disagreed with Green's opinion about whether that information indicated a search for House Long to Die in Cold was conducted at 2:27:40 a.m., he did not dispute that his 2:27:40 a.m. search artifact was present and in the deleted state during his analysis. So that kind of hurts the Commonwealth, does it not? He didn't dispute it. He's in fact said that it was there in a deleted state. Jessica Hyde also employed this methodology, originally using Cellbrite Physical Analyzer, Sanderson Forensics SQ-Lite, Axiom, ArtX, and iLeap. 4 of these tools were amongst the 5 used by Mr. Green in his analysis. In her May 2023 report and in her testimony at trial, Jessica Hyde agreed with Mr. Green and Mr. Whiffen that she had seen the 22740 AM search artifact during her analysis. In the instance of the Google search House Long to Die in Cold that was recovered with the timestamp of 2:27:40 a.m. was marked by Cellbrite as having this timestamp and being deleted. And that was her testimony from trial. She also admitted in her May 2023 report that the 2:27:40 a.m. search artifact appeared in a deleted state. She disagreed with Mr. Green's opinion about whether this information indicated that a search for House Long to Die in Cold was conducted at 2:27:40. But she did not dispute that the 2:27:40 a.m. search artifact was present during her analysis. So it's not like it just wasn't in anybody's analysis. It was there. So they're just going to pretend that it didn't exist, I guess. Inexplicably, Ms. Hyde changed her analysis and findings from her May 2023 report to align with Mr. Whiffen after a Cellbrite manipulated update. Do you get what they're putting down? So after Mr. Whiffen made this update to Cellbrite, Jessica Hyde also comes forward then and changes her opinion based on Ian Whiffen and his new update, quote unquote. Whoops, sorry. All right, so to one physical her report aligned with Mr. Whiffen after a Cellbrite manipulated update to one physical analyzer program, which the defense learned about approximately 1 week before trial began, magically removed the timestamp from value records sourced from the Safari's browser state DB. Using only this updated Cellbrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back without explanation her original conclusion that the artifact containing the 2:27:40 a.m. timestamp was present on the iPhone. So now she's saying that it wasn't there. She opined instead that the artifact containing the 2:27:40 a.m. timestamp was not present in a deleted state or otherwise, citing merely an unsupported conclusory and scientifically insufficient assertion that the timestamp was not reliable. So now they're just saying, well, it's not there now, so it's not reliable. So you just can't count it. Why are these people bending over backwards for corrupt players in this? I just don't understand. Why are these people corrupt too? And like, or they've done some things that are questionable and now the Commonwealth is holding that over their heads, perhaps? So, like Mr. Whiffen, neither Ms. Hyde nor the Commonwealth explain how the update occurred or any scientific reason for that change. So, why did this update occur? Why are we missing timestamps all of a sudden for no reason? The Commonwealth simply makes the same bold conclusory statement as Ms. Hyde that further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. This sounds like a bunch of fake BS to me. So again, I ask, why are they trying to ruin their reputations by doing this? Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 2:27:40 search artifact and this artifact alone to be unreliable. It also provides no information about the methodology of that research or any other information regarding what changes were made, how, or why. Critically, despite the manipulation associated with the unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December 2024, does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 2:27:40 a.m. search artifact. Oh God, I would love to see some cross-examination on her after this. So I kind of do hope it goes I mean, no offense, Karen. I don't want you to go through another trial. It's awful what they're putting you through. But I would love to see all these people on the stand again, just to like get really ridiculed again. I mean, I'm here for it and I will pop the popcorn. Because, wow, like what these people are going, the lengths that they're going to protect who? A retired Boston cop? No. So it must go up higher than that. So some bad MSP employees, some bad cops? No. It must be the DA, and maybe it even goes higher than that. So you guys really need to start maybe voting differently, perhaps. I'm not sure. But, anyways, all right. So, in the second report, she employs the same methodology as she did in the first trial and as Mr. Green and Mr. Whiffen employed, m- but deletes mention of an inconvenient Axiom tool that she used. Oh, so she deletes that she even used the Axiom tool in her in the May report, she used the axiom, she reported it. In this second report, she didn't mention anything about the axiom tool, which, as of this date of this opposition, continues to show the artifact. So Axiom didn't change their software. Axiom didn't do this report. or this update that changes all your reports and all the timestamps of everything and makes Cellbrite completely useless to law enforcement. So, yeah. Anyways, um, the only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensics data analysis. The appropriateness and reliability of Mr. Green's all-encompassing methodology evidenced but blah, 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 methodology is evidenced by the fact that all experts agreed and opined that at some point during the first trial that the 2:27:40 a.m. search artifact existed and appeared in a deleted search. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools so you can compare the results from different data sets and be able to compare those results and enhance those with mutual analysis. That is Jessica Hyde's testimony from the trial. And that doing so is absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company biased approach of Mr. Whiffen, to which Ms. Hyde now disquietingly has morphed. This writing is phenomenal. Robert Alessi, all of them. I mean, David Yannetti and Alan Jackson, they all are just wordsmiths. They are so good at getting points across that, like, you think it, but you're like, yeah, yeah, I didn't think of it in that way. Or, I have, that was in my mind, but now that you say it in that way, I totally get it. Like, they have a really good way of wording things, and I love it. Anyways, so the experts' disagreement is not over the methodology, but rather their opinions on whether the 2:27:40 a.m. search artifact indicates that Jennifer McCabe conducted a search for House Long to Die in Cold at or before 2:27:40 a.m., contrary to the assertion of the Commonwealth. The Commonwealth, this is parad- paradigmatic battle of the experts. It's a battle of the experts, really. And not it shouldn't be there should be no dauber hearing, none of this. Here's the argument. The court should deny the Commonwealth's request to exclude Richard Green's testimony concerning the 2:27:40 a.m. search artifact. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in the two aspects of Daubert Lanigan applicable to this motion. And that's what I said about the whole, we said that about the Marie Russell request to exclude her testimony as well. Their request was totally deficient on its face also, because it was just Hank's motion. There was no affidavit in support of anything. It was just him saying, well, she's wrong and we disagree with her opinion. And it's my word against the expert. It's not the lawyer's job to dispute the expert, it's the expert witness on their side to dispute the expert. So, yeah, I don't know. All right, so the Commonwealth claims that Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, the Commonwealth doesn't even describe the methodology of Mr. Green, which it asserts is unreliable and seeks to exclude. The Commonwealth's motion is not only bereft with respect to the two apt prongs of the Daubert-Lanigan hearing or inquiry, qualifications and reliability of methodology. We've talked about that a number of times. There's like four specific things that they need to meet. They're saying here that with respect to two of those prongs, they're not meeting it, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance precept of Commonwealth versus Davis or the five non exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question at issue here. The Commonwealth also fails to mention that Commonwealth versus Rintala instructs that the crucial inquiry for Daubert-Lanigan purposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies the Daubert-Lanigan standard, and the motion of the Commonwealth is not supported by any affidavit. An affidavit detailing all facts relied upon in support of the motion and signed by a person with personal knowledge of the factual basis of the motion shall be attached to all pretrial motions. So there needs to be an affidavit attached. It can't, like I said, be the word of the attorney. The Commonwealth additionally misses, well, actually, I take that back. It can be the word of an attorney if they are repeating hearsay of a witness or something like that, like Alan Jackson did when jurors contacted him and said that the jury acquitted her of charges one and two. He wrote an affidavit saying, I, Alan Jackson, state the following. And then he said, like, I spoke with this juror because the juror, he couldn't reach out to the juror and get an affidavit from them. So he wrote the affidavit himself. So there are instances where the attorney can write the affidavit, but in this instance, when it's an expert versus an expert, you need the expert to provide the affidavit. So just wanted to clarify that. All right, so the Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 2:27:40 a.m. timestamp lack any evidentiary support, cannot be made in good faith, constitute baseless claims. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to the cross-examination and jury determinations. Their jury duty determinations. Even if the motion of the Commonwealth was not deficient on its face, Mr. Green easily meets the requirements. So, broadly, the Daubert-Lanigan inquiry involves evaluation of both the qualifications and methodology of the proffered expert. However, the crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. In addition, under Daubert-Lanigan, the judge acting as gatekeeper is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. In questioning the assessment, the court may consider whether the scientific theory or process, 1, has been generally accepted in the relevant scientific community, 2, has been or can be subjected to testing, 3, has been subjected to peer review and publication, 4, has an unacceptably high known or potential rate of error, or 5, is governed by recognized standards. When applying this standard, judges must be careful not to invade the province of the jury. Critically, it is the qualifications and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion, which is all this is, present issues of credibility which are properly reserved for the jury, not Hank and not the judge. Once the expert's qualifications were established and assuming the expert's testimony met the standard of Commonwealth versus Lanigan, the issue of credibility was for the jury, not the judge. Accordingly, expert witness testimony should not be deemed unreliable simply because there is a disagreement of opinion or in the level of confidence among the experts. Um, Note something, or because the judge disagrees, with the expert's opinion or finds the testimony unpersuasive. Such disagreements make up the battle of the experts. 1. Richard Green's education, training, experience, and familiarity with digital forensics qualify him, sorry, not disqualify, qualify him as an expert on the topic. As to the crucial inquiry of the Daubert-Lanigan standard, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensics technician and more than 18 years of experience conducting electronic data analysis and investigations. See his affidavit from January 2025. Mr. Green has been accepted as a digital forensics expert approximately 24 times in the United States. See the motion. Mr. Green was qualified and testified as an expert for the first time in 1996 after spending approximately a decade working in computer information technology and networking, building a line of computers and doing computer repairs. In 2006, Mr. Green started a digital investigation firm called United States Forensics, or USF, which they'll call it later, which he still owns and operates today. His company handles between approximately 100 and 120 cases per year and receives annual inquiries for about 3 times as many. So he has to turn down work. He's that busy. His company has worked on civil and criminal cases across the country in both state and federal court and on behalf of both defense teams and law enforcement. Since starting United States Forensics nearly 2 decades ago, Mr. Green has worked full-time in digital forensics. In addition to being the company's president and founder, he performs the majority of the investigations. He specializes in computer, cell phone, cloud, audio, video, metadata, media, surveillance systems, and other similar systems. Mr. Green has significant education, training, and experience in the field of digital forensics. He holds an associate's degree in digital forensics and computer investigations. He is a certified computer examiner, a CCE, with the International Association of Criminal Investigation Specialists, and he also holds computer-related crimes investigator, cybersecurity, and computer forensics first responder certifications. So, I mean, he knows what he's doing. This isn't his first time doing this kind of thing. He is also a member of 4 professional associations in the field of digital forensics and was the keynote speaker on electronic data forensics at the National Association of Legal Investigators 2008 Midwinter Conference. Over the last 18 years of full-time work in digital forensics, Mr. Green has received daily on-the-job training. Namely, in addition to work he does every day at his company, he has participated in listservs, conducted research into the newest developments in digital forensics, and attended training seminars approximately once per week. In total, he has participated in hundreds of training events offered by software companies who provide the digital forensic tools used by the experts in this case, including Cellbrite, Magnet Forensics, and Belkasoft. So he has extensive training in the tools that he's using for this case. So there's that. Mr. Green has attended 67 of his trainings, not inclusive of many of the web training sources that Mr. Green follows on a continual basis since 2002. Notably, Mr. Green has attended trainings hosted by Cellbrite and Magnet Forensics every year for the last 3 consecutive years and by Belkasoft in both of the last 2 years. His affidavit is attached with his other qualifications. On December 31st, 2024, despite Mr. Green's robust digital forensics credentials and experience, The Commonwealth moved to exclude the proposed testimony of Mr. Green as to the 2:27:40 a.m. search. So he's got this experience and he's testified in this case already, and yet here we are. Commonwealth's motion should be denied. The education, training, and experience described by Mr. Green is not only overwhelming in its own right, but also much more significant than that of the proffered prosecution expert Ian Whiffen. I like that. I like that dig. Sorry, I just do. According to his own trial testimony, Mr. Whiffen has testified in the United States only once in his entire career in Michigan. Whiffen also admitted at trial that, unlike Mr. Green, he has no specific certifications in digital forensics other than a higher national certification in computing and does not have a degree in digital forensics or otherwise. By proffering Mr. Whiffen as an expert witness, the Commonwealth has tacitly affirmed its belief that Mr. Whiffen is qualified. Accordingly, the Commonwealth's arguments regarding Mr. Green's qualifications should be rejected. So, hey, if your witness that you are putting on the stand, you're saying that they're qualified and they have way less qualifications than my guy over here, then how is my guy disqualified? Doesn't make any sense. So, these are some really good arguments. I have no idea what Judge Bev is going to do. What do you guys think? Let me know in the comments. I feel like this is painting her in a corner where she's going to have to make a choice eventually. Do you show your hand that you are corrupt and hiding things for Michael Morrissey, or do you do the right thing and dismiss the charges? So let's see what she does. Time will tell. I don't know. I really don't know at this point because it's coming down to that. So, contrary to the Commonwealth's contention in their motion, Mr. Green was not broad and vague during cross examination. In fact, Mr. Green answered clearly and completely the only question the Commonwealth asked him about his training experience and certifications. Out of the 5 digital forensics tools Mr. Green used to evaluate the data from Jennifer McCabe's iPhone 11, Attorney Lawley chose one, Cellbrite, and asked Mr. Green if he had a certification for that particular platform. Mr. Green stated clearly after seeking clarification of the question that he had no such certification. He added that his certifications are much broader as they concern digital forensics fundamentals, how to conduct investigations, and which tools to use. His answers were specific and appropriately detailed. The Commonwealth statement is thus incorrect. Curiously, according to the Commonwealth's own argument by omission in this motion, Mr. Green remains qualified and his methodology is reliable in the several other areas of data forensics that he testified about in the trial. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot of the contact for Uncle Brian A. deleted from Jennifer McCabe's phone, the location data from her phone, the health data from her phone, the location data from John O'Keefe's phone, and the health data from John O'Keefe's phone. So the health and the location data. That the Commonwealth does not challenge Mr. Green's qualifications as to these topics in further evidence as his imminent qualifications, such a challenge would fail, and he should, as this one should. So, yeah, he's saying that, I just totally lost my train of thought. Oh, they're not challenging anything else, any of the other data, his opinions on any of the other forensic data that he's come up with. It's just the 227 phone call. So why are they challenging that so hard? Because it's the number one exculpatory thing, I would think. Um, because it's consciousness of guilt, it's knowing before anybody found the body. So I think this is why they're fighting it so hard. And because it covers up Nicholas Guarino's nefarious misconduct, allegedly, alleged misconduct. All right, so Richard Green's methodology is reliable. The Commonwealth's papers fail to identify a methodology for Mr. Green, let alone state why his methodology is flawed. And in fact, the Commonwealth cannot make such a statement because Mr. Green not only employed the same methodology as the Commonwealth's proffered experts, but expanded upon that methodology by utilizing more tools, performing additional low level analyses, and examining overall user activity. The validity of Mr. Green's methodology is evidenced by the fact that all experts employed it and acknowledged at some point during the first trial that the artifact containing the timestamp existed and appeared in a deleted state. So that's not in dispute here. We all agree. Um, in Whiffin's testimony. So the 22740 timestamp was correct insofar. Oh, we read that already. That was part of the. Yeah, it was indeed a deleted record, and then Hyde said it too. So that's. I don't know why I'm crossing it out. We read that already. They provided that. All right. So nonetheless, the Commonwealth now asserts that Mr. Green's methodology is somewhere or somehow unreliable. It provides no competent evidence to support this contention. With little support, it provides for its ipsy-dixit assertions on issues for the jury and not the Daubert-Lanigan inquiry, misconstrues the evidence. I believe ipsy-dixit means like just believe us, like just trust me, bro, kind of thing, but in Latin. Hold on, let me look it up and I'll tell you. Yes, according to Cornell law, ipse dixit is a Latin term that translates to he himself said it. In legal context, it refers to an assertion or statement made by an individual based solely on their own authority without any supporting evidence of proof. You, Hank Brennan, ipse dixit. That's what you did. So there you go. So the Commonwealth claims that Mr. Green admitted that his misinterpretation of data caused Cellbrite to update its physical analyzer program to remove the artifact containing the 2:27:40 a.m. timestamp. But a proper reading of Mr. Green's June 21st testimony transcript makes clear that the question was poorly stated to the point of incomprehension. In his answer, Mr. Green was making the point that as of June 21st, 2024, Cellbrite had two contradictory versions of Physical Analyzer on the market. In one version, Insolit's Physical Analyzer, the 2:27:40 a.m. search artifact has been removed, while another version, Physical Analyzer 7, still showed the artifact in a deleted state. Beyond that, Mr. Green was simply stating his awareness that Cellbrite made changes to its software sometime after his viewing of the 2:27 a.m. See, this is in Hank's filing, it was like, well, Richard Green admitted to making a mistake and misinterpreting things. No, no, he didn't. He admitted that he knew there was some kind of update that changed the data, the timestamp stuff, but no, he didn't admit to like misinterpreting things. That's on Cellbrite for updating their software. Unbelievable. So this purported evidence of supposed unreliable methodology is not about methodology at all. It is about two Cellbrite programs out of the market at the same time that are representing differently about the or that are presenting differently about the 2:27:40 a.m. search artifact. This is a problem caused by Cellbrite, not by Mr. Green. Exactly what I just said. Moreover, the problem is for the jury to determine it is not a Daubert-Lanigan methodology issue. It therefore does not support any basis for exclusion of any portion of Mr. Green's testimony under Daubert-Lanigan. Damn, so it doesn't support it, and you don't meet anything for an evidentiary hearing, so you can't exclude his testimony or bring him in for a hearing so you can basically get a second bite at the apple of of hearing his testimony. The Commonwealth also claims that Mr. Green's opinions lack any evidentiary support, cannot be made in good faith, constitute baseless claims, and have been quote unquote debunked. This is my favorite because that was even in their filing. The title of their filing was that Richard Green's opinions have been debunked, which is absolutely not true. So, first, contrary to these false and baseless assertions, Mr. Green's opinions are backed by significant scientific evidence. Uh, See all these things, right? So, see January affidavit, digital investigation techniques, that's a paper or something, and draw on the very same data contained in the raw image file obtained from Jennifer McCabe's iPhone 11, which all three experts relied upon. Second, even if these claims were accurate, the purported lack of evidentiary support the Commonwealth alleges would go to the weight and credibility of Mr. Green's opinions, not to the threshold question of whether his methodology is reliable. Once the experts' qualifications were established, the issue of credibility was for the jury, not the judge. Likewise, the Commonwealth claims that Mr. Whiffen performed a comprehensive study of the forensic data and that there is no evidence whatsoever on this device of a search conducted prior to 6:23 a.m. or of deletions. These claims are false. First, Mr. Whiffen did not perform a comprehensive study because he only looked at limited data, only used two tools, and relied nearly entirely on one, his company's tool, his own tool. His analysis is certainly less comprehensive than that of Mr. Green, who used five tools. Second, there is evidence in the raw data from this device of the 2:27:40 a.m. search artifact and of deletions. This evidence was found in all five of the forensic tools and used by Mr. Green, and the most up-to-date version of Axiom continues to show the 2:27:40 a.m. search artifact in a deleted state. Notably, Mr. Whiffen qualifies his statement to the contrary with of the data I examined. So, of what he was given, not all of the data. He didn't get all the data. Mr. Whiffen does not mention, let alone account for the several anomalies Mr. Green discusses in his affidavit accompanying this opposition that undercut the entire December 2024 report of Mr. Whiffen. In any event, these claims by Mr. Whiffen are no more than reiterations of his opinions and thus clearly are not a Daubert Lanigan matter, but are cross examination and jury matters. The Commonwealth's claim that Ms. Hyde conducted an encompassing review is similarly false. Hard to say words sometimes, your tongue gets in the way. In fact, most recently, Ms. Hyde did exactly the opposite, contravening her own first trial testimony about the importance of using multiple tools. She produced a new report in December 2024 relying only on the updated Cellbrite physical analyzer. These phrases and claims used by the Commonwealth in its motion are not just incorrect, they further demonstrate a fundamental misunderstanding of Daubert Lanigan's two core concerns, the province of the judge in a Daubert Lanigan concept and the province of cross-examination and the jury. These are not the only errors the Commonwealth makes in its motion. For instance, the first footnote of the Commonwealth's paper is incorrect. Cellbrite is not the leading forensic data extraction software tool. Cellbrite is a company, one of the companies that provides one of the data forensic tools relevant in this case. It is clear that the Commonwealth's myopic focus on Cellbrite physical analyzer is misleading and allows the prosecution to disappear the 2:27:40 a.m. search artifact. Despite Jessica Hyde's testimony during the first trial about the absolute pertinence and value of using multiple tools, The Commonwealth seeks to discredit Mr. Green, who did exactly that, while proffering experts who rely almost exclusively on Cellbrite Physical Analyzer to perform their analyses. This contradiction sheds light on the undeniable effect of the Commonwealth's motion. Now discuss only one data forensic tool, Cellbrite Physical Analyzer. Manipulate all the Cellbrite Physical Analyzer programs through some black box process in the electronic backroom of Cellbrite so they can no longer show the artifact containing the 2:27:40 a.m. timestamp and euphemistically label the mysterious and suspicious process an update. The language of this filing is beautiful. Then claim Mr. Green is unqualified and this methodology is unreliable simply because he will not play along with the manipulation of the Cellbrite physical analyzer programs, especially in light of the Axiom program previously used by Commonwealth's witnesses Guarino and Hyde, still showing the artifact containing 2:27:40 a.m. timestamp and in a deleted state. In addition to the prosecution's newly contrived debunked narrative being false, the debunked parlance in the Daubert-Lanigan motion is inappropriate and can be seen as an improper attempt to garner media headlines and otherwise prejudice future jury pools. So they're claiming that they might be trying to prejudice some jury pools there. Mr. Green's methodology is generally accepted in the relevant scientific community such that this court need not reach the five non-exclusive Daubert-Lanigan factors. Mr. Green's methodology was employed by the Commonwealth experts in this case, and it is supported by relevant digital forensics literature on best practices from the National Institute of Standards and Technology and all that other stuff. As a result, Mr. Green's technology is properly regarded as generally accepted in the relevant scientific community. Under Commonwealth versus Davis, this general acceptance by the relevant scientific community is sufficient. Therefore, pursuant to Davis, this court need not reach the five non-exclusive Daubert factors. I think I said there were four earlier. I guess there's five. All right, so even if this court reaches, so these are the five. So one was the methodology. Two, even if this court reaches the five non-conclusive Daubert-Lanigan factors, Mr. Green satisfies them. Mr. Green's acceptance of because general acceptance of Mr. Green's methodology by the relevant scientific community is sufficiently well established. This court need not reach the Daubert-Lanigan factors. However, even if the court reaches those five non-exclusive factors, Mr. Green's methodology satisfies the Daubert-Lanigan precepts. Again, as to the first factor, Mr. Green's methodology is generally accepted in the relevant scientific data forensics community and indeed by the Commonwealth's proffered data. Forensics experts themselves. Digital investigation, all of that is a source. Okay, so this regular testing is made apparent by the many legitimate updates and improvements made to the tools by their respective companies, which result in the periodic release of new versions of these tools. Third, while the methods used in digital forensics investigations are not peer-reviewed in a formal process, trustworthiness is established by members of the digital forensic community trying out proposed methods, testing, and circulating updates within the community. Fourth, the methodology also does not have an unacceptably high known or potential error rate. The Commonwealth's own proffered experts endorse and employ this methodology as scientifically sound, reliable, and accurate. Finally, the methodology is governed by recognized standards. Nonetheless, all the proffered data forensic experts in this case are using the same methodology and, in various instances at various times, using the same or similar data forensic tools. In all events, the Daubert-Lanigan factors are non-exclusive, so no factor is dispositive. Note all of the factors identified in Daubert will be applicable in every case. The trial judge accordingly has broad discretion to determine how to assess the reliability of expert testimony. Because Mr. Green is qualified and his methodology is reliable, the court must deny the Commonwealth's motion. Commonwealth has not shown that an evidentiary hearing is even required. So Daubert-Lanigan evidentiary hearings are canceled in Massachusetts once papers in opposition to the request for such hearings are filed, demonstrating the lack of a need for the hearing. So this piece of paper alone, well, not this particular, this document alone should cancel any Daubert-Lanigan hearings that you have scheduled for Richard Green. Affirming judge's decision made on the basis of the parties' papers and arguments not to hold an evidentiary hearing and to admit the expert's testimony. So she can just admit the expert as is by reading this paper and cancel the hearing. This is another case that fits this under that proposition. The core concern of the Daubert-Lanigan standard is promoting reliability by ensuring an expert has sufficient qualifications and employs a reliable method. This opposition establishes Mr. Green's eminent qualifications on the subject matter in dispute and the reliability of his methodology. That's why this is so well written, because it's like, no, we're not coming in for a Daubert hearing. This is why. Commonwealth's bare and conclusory assertions to the contrary are insufficient to warrant an evidentiary hearing on the issue of the artifact containing the 2:27:40 a.m. timestamp. The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from his transparent and disquieting campaign to deny Ms. Reed the ability to present her own defense through her own qualified and reliable witnesses to prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case, and to drain Ms. Reed of her resources in advance of trial in the process. So not only are you taking money away from her while doing all these hearings, she's got to pay for it. She's got to bring all these people in, fly them in, house them, feed them, whatever. And it's also taking up the time of her attorneys that could be working on something else that is pertinent in this case, besides doing these Daubert-Lanigan hearings. So they are really trying to obstruct, I think, Karen from being able to defend herself here. So, by submitting conclusory and insufficient motions under the guise of Daubert-Lanigan, the Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource-intensive mini-trials, thereby needlessly expending limited defense resources and diverting them from trial preparation. Through this misuse of Daubert-Lanigan, the Commonwealth also effectively is obtaining depositions of defense expert witnesses, including the attempted locking in under oath of their testimony for use at trial. Like I said, trying to get a bite at the apple twice. And this also, he brings up a good point to lock them into a certain answer so that he could try to impeach them later, which is like, that's not how you're supposed to do it. This instant motion and others like it are tantamount to legal tyranny. Legal tyranny. You are a tyrant, Hank. Not a search for truth and justice. Allowing the Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudential consequences of the Commonwealth's actions, which would extend beyond the instant case. Allowing the Commonwealth's motion would set a precedent that when the Commonwealth does not like a proffered expert's opinion, it may file rote, vague, and legally insufficient and vexatious Lanigan Daubert-Lanigan motions to exclude the proffered expert, and most important, the evidence associated with the expert. That is, the Commonwealth will make Orwellian unpersons of the evidence, which is problematic for its theory. They're just going to disappear things that don't fit their case, even though they have no legal standing to do so. The danger of this approach by the Commonwealth and the precedent it would set cannot be overstated and respectfully should not be countenanced by this court. For these reasons, the Commonwealth's motion, along with its included request for an evidentiary hearing, must be denied. For these reasons, Ms. Reed respectfully requests that the Honorable Court deny the Commonwealth's motion to exclude certain testimony of defense witness Richard Green and its included request for the evidentiary hearing. So there you have it. Like I said, it was signed by Robert Alessi, so he'll probably be doing there is a hearing. I totally forgot to mention Friday this week. There is a hearing for this very thing. There's supposed to be a Daubert hearing, so we will see if it goes. Let's see. So this is now the affidavit of Richard Green. These are his experiences, his words. I mean, the defense team writes it up, but they interviewed him and then reiterated it back. So this is an affidavit of Richard Green in support of defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. I, Richard Green, under oath, do depose and state as follows. The following facts and information are based on my own personal knowledge, and I could testify pertinently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and that I have no personal interest in the outcome of this case. I am the owner and president of United States Forensics, LLC, hereafter USF, a digital forensics and data forensics company that provides services to clients nationwide. A copy of my curriculum vitae is attached hereto as Exhibit A. I don't believe we have that. But we do have a lot, so that's okay. All right, so I have more than 25 years of experience. This is what his vitae is going to say, anyways, as a computer forensics technician and 18 years of experience conducting electronic data analyses and investigations, including analyzing computer data, cell phone data, cloud data, digital camera and DVR data, metadata media, and audio and video analysis and enhancement technology. I have conducted thousands of investigations involving computer and cell phone forensics, data recovery, computer networking and maintenance, and audio and video enhancement. So he's pretty much run the gamut of. I mean, I don't know what's left. I don't know anything about technology, so I don't know if there's other categories, but he seems to have a wide variety of knowledge here. My services have been retained by numerous attorneys across the country in both civil and criminal cases. So, again, he's uh, highly qualified and he's done this many times. I have been qualified as an expert in digital forensics in numerous state and federal courts throughout the nation, including California, Florida, Michigan, Kentucky, North Carolina, Ohio, and Massachusetts. I obtained my associate's degree in digital forensics and computer investigations from St. Petersburg College. I am a certified computer examiner with the International Association of Computer Forensic Examiners, which is a globally recognized certification in the field of computer forensics and requires continuing education and recertification every 3 years. I also hold the following certifications: a computer related crimes investigator certification from St. Petersburg College, a security certification from same and a computer forensics first responder certification. I am also personally licensed to operate a private investigation agency in both Florida and Michigan, which is a requirement to operate a digital forensics company in both states. I am presently a member of the following professional associations in the field of digital forensics: International Society of Computer Forensic Examiners, the International Association of Computer Investigative Specialists, the National Association of Criminal Defense Lawyers, and he was a keynote speaker on electronic data forensics at the 2008 Midwinter Conference hosted by National Association of Legal Investigators. So I'd say he has a pretty well-known reputation in the community when you're a person who's involved in that many associations, and especially when you're presenting as a keynote. I mean, at an association's annual meeting, you're likely pretty qualified, I'd say. So throughout my career, because they vet people, most associations have like a whole vetting process to get a keynote speaker, and they have to meet certain criteria for that too, which is probably a whole lot different than being on the stand. Maybe even more so, that you need more qualifications than being able to just testify on the stand. I would assume you would need to fit a certain level of expertise there. So, anyways, throughout my career, I have kept current with developments in electronic data and analysis, including computer forensics and investigation training from St. Petersburg College and first responders training from Institute of Forensic Imaging. I participate in computer forensics listservs, personally research the newest developments in digital and computer forensics, and attend weekly training seminars in digital forensics. A partial list of training events I have attended over the course of the last several years alone included but not is not limited to, and he lists a bunch of stuff. And he says this list is not inclusive of many of the web training sources that I follow on a continual basis. And he lists, as you can see, many trainings that he has attended, likely in person, all of those, or virtually. All right, so initial data production. USF was initially provided with a Cellbrite UFED report prepared by Trooper Nicholas Guarino with the Massachusetts State Police, which was labeled as a full file system extraction of an iPhone 11 with a serial number ending 72W, belonging to Jennifer McCabe. In the initial report prepared by Trooper Guarino, the 2:27 a.m. search for House Long to Die in Cold did not appear in his report. So, recognizing that this report was not the best evidence, I personally requested the image file for the phone in question, which I had reason to believe was produced using the Gray Key product, another product that they use, based on the naming and convention contained within the Cellbrite report. I subsequently received a USB drive containing a forensic image of the iPhone 11 serial number ending in 72W, described as J. McCabe, belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant District Attorney ADA Lally. So Adam Lally sent this USB drive to um, Richard Green with the Norfolk DA's office by way of Trooper Guarino with the Massachusetts State Police. Upon receipt, the USB containing the image of Jennifer McCabe's cell phone was assigned an internal evidence number, which was with USF evidence number 304, ending in 304. Notably, the USB drive containing the forensics image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value. So we're missing hash values that we need, which is a well-known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. So without those hash values, you can't completely validate the files. You could say that it had been manually manipulated by someone, perhaps. All right, so after personally insisting that the Massachusetts State Police provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within the PDF matched the gray key image file of the cell phone in question. After obtaining the full file system extraction of the data contained on Jennifer McCabe's phone, the data images were processed and reviewed with Cellbrite Physical Analyzer and Axiom Forensics, and he provides the version numbers here. Opinion number 1. It is my opinion based on a reasonable degree of scientific certainty that the user of Jennifer McCabe's cell phone searched "House Long to Die in Cold" at or before 2:27 and 40 seconds in the morning. In my professional experience, an analysis of a device's internet search history often gives valuable clues as to the user's intent or knowledge surrounding an incident. I conducted a review of the search history information obtained from Jennifer McCabe's iPhone 11 and observed the following significant artifact from the morning in question as reported by Cellbrite Physical Analyzer and Axiom Forensics, which were the most recent versions of the respective tools at the time I conducted my initial analysis. So he had the most up-to-date versions, so nothing about having the wrong version, like they tried to say was like the smoking gun, you used a different version, didn't you? Anyways, so search term "House Long to Die in Cold" last viewed was at 2:27 a.m. And here's the Safari link. The Safari suspended tab state deleted WAL file. Cellbrite processing. In Cellbrite Physical Analyzer, the 2:27:40 a.m. House Long to Die in Cold search not only showed up in the web history, but Cellbrite further refined the results and included in it the searched in items artifact section. It was marked as a deleted record with an adjusted last viewed timestamp of January 29th, 2022 at 2:27:40 a.m. Noting the inconsistencies in Cellbrite's reporting between the UFED report generated by the version ending in 2.9 and Cellbrite's physical analyzer, I contacted Cellbrite's technical support to inquire if they could provide additional information about this artifact. Cellbrite's technical support staff indicated that they believed the artifact was reliable and that no issues had been brought to their attention. On August 22nd, 2024, the Commonwealth's expert, Ian Whiffen, emailed me. Let me backtrack. On April 22nd, 2024, Ian Whiffen, Commonwealth's expert, emails Richard Allen. I mean, not sorry, Richard Green. Wrong case. Richard Green, the forensic data expert. That's unheard of. It should not be happening. Ian Whiffen should not be communicating with the other side whatsoever. If he needs to communicate with anybody, it should be with Adam Lawley. All right, so on April 22nd, 2024, the Commonwealth's expert Ian Whiffen emailed me stating the last visited time shown in PA will be getting removed from the artifact in the next available version of the physical analyzer. After the start of the trial in this case in late May of 2024, Cellbrite released Insights, I don't know how to say that, physical analyzer, which removed the 2:27 a.m. timestamp from its processing of the artifact. Shortly after trial on July 22nd, 2024, Cellbrite released its Cellbrite Physical Analyzer Standard, which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Cellbrite is a company that markets itself as providing digital intelligence solutions for law enforcement. So why the heck are you going back and deleting things? And is used by over 6,900 public safety agencies in over 100 countries worldwide. Cellbrite, why you going and changing shit and then you're not going to have timestamps that are accurate for real crimes, crimes that you're not framing people for. Anyways, although I am aware that Cellbrite recently changed its analyzer program so that it no longer reports on the timestamp of this particular artifact, I have not misinterpreted the data as Hank Brennan has tried to tell us. All right. All right, so Axiom Processing. Axiom is an application product offered by Magnet Forensics, which is a competitor of Cellbrite. Best practices in digital forensics require forensics examiners to view data and artifacts with more than one tool. Therefore, I also process the image of Jennifer McCabe's iPhone using Axiom version 6.11. Axiom version 6.11 reports the 2:27 a.m. search artifact for House Long to Die in Cold with a last viewed time of 2:22:40 a.m. in the Safari suspended state tabs section. Shortly thereafter, I contacted Magnet Forensics technical support to see if additional information could be provided regarding this artifact. I was advised by technical support that the 2:27:40 a.m. timestamp indicates that the search would have occurred sometime at or before the 2:27:40 a.m. time indicated. I would also note that Trooper Garino's report, labeled ending in CNFB PDF, specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's iPhone. I personally tested the earlier version of Axiom, which would have been in February 2022, and determined that the 2:27:40 a.m. version of How Long to Die in Cold Search was reported by Axiom as having the last viewed time as same time, 2:27:40 a.m. Axiom has a similar feature to Cellbrite with their creation of a portable case. This exculpatory information was never provided to the defense. Brady violation. Big ol' Brady violation. Drop these charges immediately, is what that is telling me. And I really hope they do. Where did I leave off with the footnote? Oh, okay, so here. Since my initial analysis, USF has upgraded to the more advanced Axiom Cyber Physical Analyzer, which was released on December 17th, 2024. This version of Axiom continues to report the above artifact with an even more precise last viewed date time of 1/29/2022 at 2:27 and 40.465 seconds AM. So now we're getting even more detailed, more down and dirty into the details of this search in the Safari Suspended State tab marked as deleted. Moreover, Axiom's user manual describes this artifact as follows: Safari Suspended State tab's last interaction date time, UTC year month date, as the date and time of the current tab's state that when it was last interacted with on the local device. So that's their own, this is what the user manual of Axiom says. The date and time that the user last interacted with the local device. This date and time will reflect when the user has last interacted with his tab in Safari and if the tab auto-refreshed on the local device only. In order to validate this timestamp, I looked at numerous examples of web sessions on Jennifer McCabe's devices, including URLs containing Raining Men, Canton MA or .org, HockomockSports.com, and EasternBank.com. In all of these instances, the browser state DB entry appears at the end of the session. This is consistent with how Magnet describes this artifact. In order to confirm the accuracy of this search event as reported in Cellbrite and consistently throw out multiple versions of Axiom, I then independently performed a low-level analysis of the artifact, which was located in the browser state DB wall write-ahead file. Write-ahead files are temporary in nature and show the location where data is written before commitments to the main database are made. Okay. The particulars of this artifact are as follows. So, location, private, mobile, library, Safari, browser, DB wall file. And there's a raw time, date, raw time data. I don't know what that is. That's not a date or time. Time converted, 7:27:40, adjusted to local time, 2:27:40. I used 3 additional forensic tools to conduct a low-level analysis of the artifact in question, including Belkasoft X, Sanderson Forensic Browser, and ArtX2, a research-based program created by the Commonwealth expert Ian Whiffen, which only has approximately 600 users worldwide. I love that he threw that dig in there because Ian Whiffen threw that out on the stand that he only has 600, not even 6,000, 600 users worldwide, whereas Cellbrite, like thousands. So, all right. So all 3 of these programs show data consistent with a search for how long to die in cold, with a last viewed time field of 2:27:40 a.m. being found on record 4028. All times listed have been converted to Canton, Mass. Local time unless otherwise noted. Thus, I was able to independently verify using additional forensic tools that the last viewed time, date, and fact of the search was accurate. It is my opinion based on the reasonable degree of certainty that the user of Jennifer McCabe's cell phone searched House Long to Die in Cold at or before 2:27:40 a.m. I have also consistently reported the existence of 2 additional search artifacts found on the forensic image of Jennifer McCabe's iPhone, which suggests that the user of Jennifer McCabe's iPhone 11 made 2 additional similar searches later that morning at 6:23:51 a.m. and 6:24:18 a.m. And first one is the second misspelling, and then the second search is the time she misspelled it at 2:27 a.m. Opinion number 2. It is my opinion based on reasonable degree of scientific certainty that the 2:27:40 a.m. search artifact for How Long to Die in Cold was deleted either deliberately or either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. Could it be the Commonwealth? Could it be Matt McCabe, who works in IT? I don't know, but it's all very suspicious. So it is uncontested that the 2:27:40 a.m. search artifact for How Long to Die in Cold found in record 4204028 is in the deleted state. Databases contain tables with numerous fields, and in some cases there is a programmable field entry to indicate whether a record is live or deleted. With regard to the browser state DB, hold on. With regard to the database DB, which is the database at issue here, there is no such field to indicate whether a particular record is live or deleted. However, based on the characteristics of the data contained within the associated write ahead log or the wall file, the forensic tools indicate that the 2:27:40 a.m. search found in record 4028 is in a deleted state. There are several reasons why data may appear in the deleted state, which include a deliberate user interaction, so Jennifer McCabe probably deleted it, an automated function of the operating system. Sometimes you can automate things to delete. That's probably not what happened here. A system application or operating system update, a malfunction of the operating system or hardware, or manual post-imaging manipulation of the data itself. I address each of these potential scenarios in turn. Manual post-imaging manipulation of the data. Typically, data collections have an associated, oh, why does that cut off? That's strange. Um, Typically, data collections have an associated hash value with which is unique to the set data. The hash value is created using an algorithm and is a well-known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. In this case, USF was originally supplied with the forensic image of Jennifer McCabe's cell phone, which was created using a tool known as Gray Key from Assistant District Attorney Adam Lawley with the Norfolk District Attorney's Office by way of Trooper Guarino with the Massachusetts State Police. However, and remarkably, the associated documentation containing the hash value needed to validate the image was not provided. So that hash value again comes up. Hash value not provided to validate the image with the initial USB drive containing the forensic image of Jennifer McCabe's cell phone. So that USB given over by Adam Lawley from Trooper Guarino missing the hashtag. This was incredibly unusual. In all of my years working as a forensic examiner, this is the first time I have ever received a forensic image of a phone without the corresponding hash value. So, and, and he's 25, 30 years he's been at this, so he knows. After personally insisting that the Massachusetts State Police provide the hash value associated with the data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within the PDF matched the gray key image file of the cell phone in question. However, as Mr. Whiffen acknowledges in his report, the Cellbrite program cannot validate the data because the value is unsigned, no hashtag. In other words, the gray key image of Jennifer McCabe's cell phone could have been manipulated, then rehashed after the manipulation, and still show the same resulting hash value included in the PDF file. Typically, forensic examiners are provided with the raw image file and the associated hash value documentation together. After validating the hash value, I would then accept that the data has not been manipulated. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. As a forensic examiner, having received hundreds of imaged phones over the course of my decades, this was unprecedented. In addition to law enforcement's failure to initially provide the hash production or documentation associated with the raw image of Jennifer McCabe's cell phone, there were additional anomalies within the process data that are suggestive of manipulation as reported by tools such as Cellbrite and Axiom. These anomalies, discussed in further detail below, along with other anomalies in this case, including law enforcement's failure to properly document the chain of custody of items of evidence, inconsistencies in official reports and testimony regarding the collection of evidence, law enforcement's failure to properly photograph and document the evidence, and destruction of other crucial electronic data are all suggestive of post-imaging manipulation. So he just listed out a whole bunch of reasons why this could have happened. And it's not looking good for Trooper Reno. as the captions called him in during the trial. It would say Trooperino, splicing Trooper Garino into one word. So I like that. Trooperino has some splaining to do. Malfunction of the operating system or hardware. In my experience, iPhone hardware and the iOS operating system are very reliable. In this case, there is no data or evidence to suggest that a malfunction of the operating system or hardware caused the deleted record. So he rules that out. System application or operating system update. The structure of databases can change from version to version of the iOS system or associated applications. Upon analyzing Jennifer McCabe's cell phone, which is the cell phone at issue, I was able to determine that the iOS on the device was updated to version 15.2.1 on January 24th, 2022. This update occurred before the record in question was generated on January 29th, 2022. This would not have caused the deletion, so that's not what the problem was. Automated function of the operating system. The artifact in question is found in a write-ahead log, the WAL file. The data is written to the temporary WAL file in order to aid in speed and ensure data integrity. You can think of this as the database brings a series of Excel spreadsheets where the data is structured into fields, rows, and columns, and the WAL file text as a notepad text document where you can quickly add data that you intend to eventually write into the Excel spreadsheets. The mechanism for writing the data from the temporary file to the associated database is called a checkpoint. Here, with regard to the 2:27:40 a.m. How Long to Die in Cold WAL file at issue, the data establishes that the last checkpoint occurred on 1/28/2022 at 7:39 and 3 seconds in the morning a.m. Therefore, the deleted state of the 4028 record is not a function of the WAL file being written to the database because the last checkpoint occurred the day before the January 28th, 2022. I am aware of no internal mechanism for spontaneous record deletion. So it didn't just up and delete itself for no reason. Mr. Whiffen similarly concedes in his report that he is unaware of any intentional mechanism for record deletion. Deliberate user interaction. As stated above, there is no intentional field within the browser state DB database to indicate whether the artifact in question was user deleted, as in a column labeled deleted with a corresponding entry of yes or no. No such field exists in the browser state database. However, as explained in further detail below, additional anomalies found on the phone strongly suggest that this data was either the result of deliberate user interaction or post-imaging manipulation. So it is his belief it was one or the other. Either someone did it deliberately, a user did it, or there was some post-imaging something, and that seems nefarious too. So my forensic analysis of the image of Jennifer McCabe's cell phone unwavered numerous anomalies, uncovered. Oh my God, I don't know how I do that. My brain sees it, but my mouth says something else. Let me start that sentence over. My forensic analysis of the image of Jennifer McCabe's cell phone uncovered numerous anomalies or unusual deviations from which is standard, normal, or expected in a typical case. The following anomalies further support that the artifact in question was deleted either through user interaction or through post-imaging manipulation. Anomaly number 1. The most up-to-date version of Cellbrite Physical Analyzer reports 4,560 searches with only one search being marked as deleted. So that is a very, very low percentage rate there. The only search marked as deleted in the most up-to-date version of her Cellbrite physical analyzer is a How Long to Die in Cold search that was found in that record, 4028. This strongly suggests that this search was targeted for deletion. Anomaly number 2. The tab ID for record 4028 is a whole bunch of numbers ending in 53E. This number is unique to the tab in question and would have been used for all URL history in that specific tab within that particular database. The Commonwealth has claimed that the actual website being visited during this period was hockamocksports.com. However, the tab ID recorded at 2:27:36 a.m. associated with Hockamock Sports activity has a different tab ID number, specifically ending in 180. Different tab numbers. So, not the same tab. You couldn't have reverted back to another tab, Hockamock Sports. No, it didn't happen. This only proves that this search happened. I mean, more so than we already knew. Thus, the records in question clearly establish that the HockamockSports.com activity was conducted in a completely different tab than the search for How Long to Die in Cold, which also showed activity at 2:27 a.m. just seconds later. So both of them were at the same time, just happened to be different tabs though. Anomaly 3. The Commonwealth's expert Ms. Hyde and Mr. Whiffen opine that the 4028 record with the 2:27:40 a.m. timestamp initially would not have been associated with the How Long to Die in Cold search. I have examined the multiple rights of the 4028 record contained within the database WAL file, and in all instances, the URL containing the How Long to Die in Cold was present. I see no evidence of the 4028 record containing a different or blank for that field. So in no instance was it ever not reported whenever he did some kind of a search. Anomaly number 4, the search artifact associated with How Long to Die in Cold and the 2:27 a.m. one and the 6:23 a.m. one and the 6:24 a.m. one are all missing information that would be expected in the history file that Mr. Whiffen opines that the load was likely never successful as it was never populated in the history DB database. However, the Google suggestion artifact for How Long to Die in Coal or How Long to Digest Food that was at 6:23 along with the picture. This indicates that the cell phone in question had internet connectivity at the time at the 6:24 a.m. search and contradicts Mr. Whiffen's speculative suggestion that the load did not complete. So that's just his speculating over that. Anomaly 6. The knowledge C information for the How Long to Die in Cold search appears to be out of order. Knowledge C artifacts typically run a few seconds after the event in question. For example, the P-list time for How Long to Die in Cold or SICT recorded at 2:23:53 has a corresponding knowledge C entry time at 6:23:57 a.m. 6 seconds later. Typically, the knowledge C artifact appears seconds after the P-list entry. However, the 6:24:18 a.m. P-list entry for How Long to Die in Cold is followed by a knowledge C time of 6:24:24 a.m. 6 seconds later for How Long to Die in SICT. The corresponding knowledge C entry for How Long to Die in Cold does not show up until hours later, 10:33:35 a.m. Oh, I think Matt McCabe might have been doing something with the phone at 10:35 a.m. This is unusual and deviates from what is typically observed. Oh, damn. You guys are in more trouble. Anomaly number 7. Trooper Nicholas Guarino, April 24, 2023 report shows that he took custody of the phone at 2/2/2022. at 12:08 p.m. However, the gray key log indicates that the device was not accessed for imaging until 2 hours later, or converted locally at 2/2/2022 at 2:25 p.m. The report also indicates he was given the password to the phone. Nowhere within the report does it explain the time delay between receiving the device and the imaging of the phone. Interesting that, huh? It is my opinion, based on a reasonable degree of scientific certainty, that the 2:27:40 a.m. search artifact for "House Locked to Die in Cold" was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. So either way, it was done, likely deliberately. The methodology I used to evaluate the 2:27:40 a.m. search artifact for "House Long to Die in Cold," as described in this affidavit, is generally accepted in the digital forensics scientific community and is consistent with applicable National Institute of Standards and Technology guidelines as shown in Digital Investigation Techniques, a NIST Scientific Foundation Review 2022, and is attached, which we don't have. Signed and sworn to under the pains and penalties of perjury, Richard Green. I mean, yikes, did he come out swinging, him and Alessi. I have no clue what Judge Cannoni's going to do. This puts her in a bind. Honestly, it does. She kind of has to deny the Dauber hearing. She kind of has to allow his testimony, and she kind of should just dismiss the charges altogether. We know she's not going to do that, but she should. This proves that Jennifer McCabe knew unequivocally that John O'Keefe was or was going to be laid out in that lawn dying. She knew, and she is complicit because she allowed it. She helped orchestrate everything against Karen Reed. She helped get witness testimony to be on the McAlbert side, basically, implying guilt on Karen, like with the niece and nephew of John O'Keefe. The McAlberts have gotten to the O'Keefes, to the niece and nephew, to Peggy and Paul, and they were invited to court. So obviously, point is, um, they're getting words from Jen McCabe in their ear about how awful and evil Karen Reed is, and she did this, no doubt, and you have to believe me because I said so, even though there's no proof. So she's been orchestrating this the whole time. As I mean, we all knew this, but this unequivocal. So I'm glad I'm not Judge Bev. What do you guys think Judge Bev is going to do regarding this motion? Let me know in the comments below, and I will see you guys in the next one. Please hit the like button on your way out. Take care. Bye now.